Good afternoon, everyone. Thanks for joining for another Launch Lab webinar. We're always trying to add value to the startup ecosystem here in SA. Today, we're going to be looking at establishing legal foundations for your startup. And speaking to us today is a new friend of the Launch Lab, but already feels like she's been here for a long time. Leana Kotze. She's an attorney, notary, and a conveyancer, and experience in litigation and commercial law. She has a BComm, LLB, and an MBA, and there's a little more news she'll share around that in just a little bit. But she's also passionate about entrepreneurship and what it can do for Africa, and she really wants to help early stage entrepreneurs better understand really South African law as it applies to their businesses. And Leana, we're looking forward to getting into it, but we've seen a lot of naive missteps when it comes to the legal stuff and also financial stuff behind startups. When we get them, there's usually a mess, or not usually, sometimes there's a mess with what we're getting already. And with what you're talking about, early stage entrepreneurs, your passion that we're keen to hear about. So we exist to help seemingly impossible ideas become world-shaping businesses. So just echoing your sentiment there, which is why it's exciting to have you speak to our community today, because we really believe it can have an impact. World shaping will impact the world. So today we're going to focus on basic company law and cover the different types of companies and things recognized, and really just the crash course on like what you need to know about law as you get started. So Leana, thanks for joining us, and over to you. We're excited to hear from you.
Good morning, everyone. As Brandon mentioned, my name is Leana Kotze. I studied business and law and worked as an attorney, notary, and conveyancer for 5 years. And then as of this morning, I am also an MBA cum laude graduate. So I no longer work as an attorney. Aside from a couple of projects and my work with Launch Lab's Countdown program, I'm currently practicing fun employment from the comfort of my own couch. So that's why I dragged one of my former bosses and good friend, Merlin Titus, here today. He very much practiced as an attorney, so much so that he's actually the director of a law firm, Maremole Hendricks. So their website is terrible, but I assure you that Merlin is quite the opposite. He won't be presenting with me, but he will join me for the Q&A afterwards, and we'll provide you with his contact details in case you need to get in touch with a practicing attorney to help you perhaps with setting up your company, drafting some contracts, or just suing someone for fun, you know. So let's get started. So this presentation is really going to be Company Law 101. I'm sure that there are members of our audience to whom this will be old hat, but from my professional experience, I know that it is important for business persons to lay solid legal foundations when starting out. And, pardon me, as this cartoon illustrates, it can be very challenging to navigate. So I decided to begin at the beginning. So I know something that many entrepreneurs are concerned with is the registration of a company. So I thought we'd start by taking a step back and just asking why we even bother registering companies in South Africa. Then move on to different types of companies that can be registered, how to register a company, the duties of the directors of a company, and then certain issues around shares that I think will be very useful for startups. So why do we register companies? The short answer is to limit legal liability. You are what we call a natural person. You're an entity made of flesh and bone, or the universe in ecstatic motion, if you ascribe to the works of the great Persian poet Rumi. When you register a company, a new type of entity comes into existence, what we call a juristic person. This is an entity that exists only in the legal sense, not the physical. So I get that this can be a bit difficult to understand, so I've stolen a bit from Yuval Noah Harari's book, Sapiens. If the CEO of Volkswagen today ordered every factory shut, he went all Thanos and destroyed every Volkswagen ever made and fired every single employee, including himself, would Volkswagen cease to exist? No. But what if some judge in Germany ordered that Volkswagen be liquidated and deregistered as a company? Yes, then Volkswagen would cease to exist. No infinity gauntlet necessary, just a few legal papers and a judge's signature. But still, what's the point of going through the effort of creating this invisible juristic person in the first place? As I said, juristic personality limits legal liability. Whose legal liability? That of its owners, who we call shareholders. So the same way as you, a natural person, can enter into contracts, can buy and sell, can sue and be sued, a juristic person can too. In other words, a juristic person has a lot of the same rights as a natural person. Not all the same though, of course, like a company can't get married, for example. So instead of you signing a contract to rent a building for your business or to take out a loan from the bank to fund your business, the company takes out that loan. The company signs that rental agreement. So this then means that when the rent or the loan installments aren't paid, the landlord or the bank have to sue the company to get their money, not you. So in other words, by registering a company and working through it, you are limiting your personal legal liability. The whole idea behind this is that we want to encourage businesses to flourish and for entrepreneurs to take risks. But we know that those would drastically decrease if every creditor or customer could come after your assets, your savings, your investments to pay any debts and liabilities that might be owed to them by the company. Now, to be clear, juristic personalities do not provide a free-for-all. Bank is not stupid. When your business gets a loan from the bank, for example, they most likely want this loan secured by some asset. And if your business doesn't have sufficient assets to put up as collateral, the bank will ask you in your personal capacity to provide that collateral. For example, by registering a bond over your house. Now, we're not going to go into that and every other possible permutation of reality. All that you need to know is that we register companies to limit our legal liability. So, how does company registration work? In South Africa, the Companies Act, number 71 of 2008, regulates this whole process. And it states that the juristic person comes into existence when this memorandum of incorporation is filed with and registered by the Companies and Intellectual Property Commission, which I call CIPC, but I know many people call CIPC as well, whatever floats your boat. So CIPC they file this memorandum of incorporation, and then they give you a unique registration number, which is essentially like an ID number, but for companies. So this memorandum of incorporation, or as we call it an MOI, is a document that describes the rights, duties, and responsibilities of shareholders, directors, and others within a company. And it essentially sets out the rules that govern the conduct of the company. Now, CIPC is kind enough to provide a standard MOI that can be used when you register your company. You can also provide your own one. So the one that I have an example of here is the short standard form. They actually have a long form as well. But the short MOI, the standard one, really is suitable to most companies, and it can be very easily amended after registration should you have reason to do so. I, for example, use the standard short form for my own company, so really it's fine. So now we're going to look at the different types of companies that you can register in South Africa. But I think it would be useful if we first saw what happens if you don't register a company. So in that case, we say that you are doing business as a sole proprietor. In such a case, you're trading in your personal capacity, your own name. You don't have that juristic personality to shield you. Your legal liability is not limited, as we've discussed. And creditors, customers, and whoever the hell else can come after you and your assets to seek payment of liabilities. So now on to companies. The world over, there are many different types of companies that can be registered. Now, you will have seen indications of these in everyday life. For example, Absa Bank Limited or Vox Telecoms Pty Limited. Those tell us what types of companies those are. The Companies Act broadly distinguishes between two types of companies, for-profit and not-for-profit. Not-for-profit companies are those incorporated for the public benefit, and their distinguishing characteristic is that their income and property is not distributable. So those are like charities that you are familiar with. Under the profit companies, there are several types. Firstly, we have private companies. These are kind of like the most common company you'd find. Their distinguishing characteristic is that there's a restriction on the transferability of their shares. This means that you can't sell the shares in a private company to anyone in the public. Generally, in these companies, you'll see agreements between the shareholders that if one of them wants to sell their shares, they first have to offer it to all the other ones before they can get permission to offer it to someone who has nothing to do with the company. These companies need at least one director, but there's no limit on the number of shareholders the company can have. Next, we have public companies. Their distinguishing characteristic is exactly the opposite of private companies. You can freely transfer their shares to the public. And this is why these are the only types of companies that can list on the JSE. But they have far more strict requirements than other companies, such as that they must be audited, that the auditor must change every 5 years. They have to have special committees. They have to submit many, many documents to SIPC on an annual basis. They also need a minimum of 3 directors and 7 shareholders. Next up, we have public liability companies. The distinguishing characteristic of these companies is twofold. They have a more flexible profit distribution than the other types of companies do, but this comes at a price. Directors are jointly and severally liable for the debts and the liabilities of the company, unlike all the other types of companies. This is why you see them used by professionals such as attorneys and engineers and so, because society has decided that these professionals should have greater liability than other people because of the nature of the work they do. Next up, we have closed corporations. Now, this is a bit of a special one. They have fewer requirements than a normal private company. So it is essentially an easier way of doing business. The thing is, though, you can't register closed corporations anymore as of 2008-ish. But you can still buy one from someone else and use that to conduct your business. Lastly, we have SOEs, state-owned companies. So these are entities that are created, governed, and funded by governments to undertake commercial activities on the government's behalf. I'm sure I don't even need to say Telkom SOE, Eskom SOE, lest the audience get too riled up. Now, I'm by no means a tax expert, but I can show you perhaps one other thing that gives people a reason to register a company beyond legal liability. Company income is taxed at a flat rate of 28%, whereas individuals are taxed on a sliding scale anywhere between 18 and 45%, depending on their level of income. So once you start making a certain amount of money, it just makes more sense to do business out of a company than out of your own name, simply for tax reasons. So now the takeaway here, aside from those very important percentage points, is that if you want to register a company from which to operate your business, a PTY Limited is the most appropriate vehicle for you. As I said, it is the most common type of company in South Africa. So how do you actually register a company? So there are many companies online that have pre-registered or shelf companies that you can buy from them. I Googled, it's anywhere between 600 and thousands of rands that you pay them for this. I think this is absolutely ridiculous because for a mere 125 Rand through SIPC or 175 Rand through their Biz portal, you can register your own company with a standard memorandum of incorporation in a matter of hours. It is honestly as simple as going on one of these sites, registering an account, filling in some online forms, and paying them the same way you would when you do online shopping. Within a few hours or even a couple of minutes, depending on how busy their system is, you will receive a confirmation that your company has been registered and you will receive that registration number, the ID number that we spoke about. Done. Biz Portal, which is the newer of SIPC's offerings, actually even has how-to videos that are very simple to go through. So I'm not going to click through this process. That is what those videos are. But I just want to reassure you that really they want to make this. They want to foster entrepreneurship in South Africa. They want to make it as easy as possible for you to do business with them. You see here at the bottom, these are many of the other simple services that you can perform on BizPortal. You don't have to worry about things like UIF and BBEE certificates. Those will only come much later on for you. But pretty much you need to follow it up until company name, and boom, registration is done. It's incredibly, incredibly simple. Don't get taken in by someone who wants to charge you 6,000 Rand for something that you can do yourself in under an hour. So a last important thing here is when you register a company, you and your other co-founders will have different roles you need to play. You'll be a shareholder, a director, and an employee of the company. Those are three separate things. So at university, they explained it to us by saying that you'll have to wear different hats when playing different roles. Sometimes you'll wear your employee hat, for example, when you're going out on sales calls. Sometimes you'll wear your shareholder hat, such as if you vote on certain things, for example, the sale of the majority of the company's assets. And sometimes you'll wear your director's hat, such as when you sit at board meetings. It is important to know when you and someone else is wearing what hat. For example, if one of your co-founders resigns or is dismissed as an employee, he or she is still a shareholder and a director, and they will have certain duties and rights when it comes to wearing those hats. So we're going to look at some of these rights and responsibilities of directors, and then we will discuss some different types of shares next. So the duties of directors. There are many that are described in the Companies Act, but I have isolated a few of the most important ones and the ones that will most likely be applicable to you as a small business. So firstly, and most important, not most importantly, but quite importantly, you have to submit annual returns to SIPC. So these are either in the form of financial statements prepared by an independent accountant that you can upload, or it can be in the form of a statement that an accountable person within the company makes. This is essentially just a confirmation to SIPC that your business is still trading or that will continue to trade in the future. So it's kind of like a renewal of the registration of your company. Second, you have to disclose your interest in certain decisions made by the board. For example, the board wants to appoint a new accountant. If this accountant is your sister, you should tell the board about that. Also, you need to notify SIPC of certain changes. For example, changes in directors, if the company's registered address changes, if you make changes to your memorandum of incorporation, or if you decide to dissolve the company. Lastly, and this is actually the most important one, as a director, you must make sure that the company does not carry on its business recklessly, with gross negligence, with intent to defraud, or under insolvent circumstances. So what the hell? This is basically, we do this through something we call the solvency and liquidity test. Solvency relates to the assets of the company in relation to the liabilities of the company. So this test that you have to basically quickly run through in your mind every time you take a decision for the company is, within the next 12 months, in the ordinary course of our business, will the company be able to pay its debts as they fall due? So an example of reckless trading would be, you've worked out the runway of your company. You know, next week you're going down. It's over for you. And yet you still ordered 10,000 hamburgers to be delivered to your company at the end of next month. You know you won't be able to pay it, but you still do that in any case. In such a case, you could be held criminally liable and even civilly in your personal capacity. So you as the director might be ordered to pay Burger King for those 10,000 burgers because you knew at the time the company couldn't afford to pay it. So then there's also a long list of certain things that you as a director are responsible for keeping records of. These are things such as the details of directors, notices and minutes of shareholder meetings and board meetings, copies of all resolutions taken by the board, the shareholders and board committees, copies of all communications sent to and documents made available to shareholders, and then accurate and complete accounting records. The reason for this is the Companies Act says that any person with shares or a beneficial interest in the company may inspect these records at any time. So when a company is registered, it authorizes a number of ordinary capitalization shares. This can be anywhere between 2 shares and millions of shares. The shareholders that own these shares are the owners, as we discussed earlier, and they are entitled to vote on certain company issues, and they're also entitled to dividends on their shares if the directors of the board vote to pay shares. So there are different classes of shares with different rights and responsibilities that can be authorized by the company, but we are once again not going to worry about all of that now. We'll just stick to ordinary shares, which is what you deal with 90% of the time. So we've all heard stories about the spats that occur between company founders. It leads to one or more of them leaving the company while some remain, and the plainly unfair consequences that follow, such as the guys that started Snapchat. So we're going to look at 2 examples of steps you could take to protect yourself and the company against such occurrences. So let's say you start a business with 2 of your friends. You register a company with 100,000 authorized shares, and you issue 30,000 of them to yourself and your co-founders. So that means that each of you owns a third of the business. Later on, the company can issue the balance of the 70,000 that remains, for example, to investors and employees. But before that can happen, one of your co-founders decides, listen, labor is not their destiny. They decide they're going to move to Mauritius and live off the land. And thus, they no longer contribute to the company. But they're still an owner, a shareholder, who is entitled to vote on issues, to receive dividends, and to profit from the growth of the company should they later sell these shares. That doesn't sound fair, right? This is why vesting is a thing. Instead of each of you getting your full shareholding up front, you get it regularly in portions over a set period of time. So in this example, at registration, each of you gets 1,000 of the 10,000 shares that have been earmarked for you. This guy leaves, he's off to Mauritius. So your and your other co-founder shares keep growing year after year as you stay with the company and you continue working. But the guy that left stays where he is, which is in relation to what he contributed in the first place. A further example, well, a different scenario. Now again, you and your friend are starting a business, but this time, thank God, you're leaving the guy from Mauritius out. The thing is, you need a developer for your app, and neither you or your friend possesses the required skills to develop. So you get hooked up with a friend of a friend's cousin's neighbor or something like that. So this guy looks like he's got the skills, and he is going to be very important to your business's development, even though he's not one of the founders. So you want to reward him accordingly. But you don't know him from Adam. What's to say he's not going to leave as well? What do? Easy. You combine the vesting that we just discussed, that you're now an expert in, and you say to the developer, look, if you stay with us for at least 1 year, then only will your shares start vesting. If he leaves before that, he gets nothing. That 1 year mark is the cliff. But the cliff can also be a performance goal. You could say to him, if you achieve X within 12 months from now, you'll get shares. If you don't achieve X in that time, you get nothing. You may have heard of Elon Musk being awarded shares, for example, in Tesla recently, or over the past couple of months, because he has reached certain performance targets. That's an example of this. So then over time, so here's our cliff, and then the shares vest in him over time until he's there where you now felt it's a fair place for him to be. So vesting and cliffs, these are 2 really easy ways that you can incentivize the founders and employees to stick with your business and give their best, and to protect yourself and the business against key players going AWOL, leading to undesirable circumstances. Now, since we still have a couple of minutes left, I've thrown in a bonus round. This is the question I get asked most. It is really, as an attorney, this is the question you get asked most by entrepreneurs. How do I stop someone from stealing my $1 billion idea? I was fortunate enough to attend a course hosted by Professor Jan Brinkman earlier this year. He's quite big in the startup world in Europe and so. And I posed this question to him as well, because I mean, I know the legal answer, but maybe there's more to it. And he said to me, well, listen, if it's that easy to steal your idea, it's not a brilliant idea. And I quite appreciated that. But more realistically, you could enter into non-disclosure and confidentiality agreements when you discuss your ideas with for example, with investors or possible partners. Confidentiality agreements can be complex. They can be hundreds of pages long, but these are the three basic things that they need to contain. Describe the confidential information, have the other party agree to keep the confidential information confidential, and then they must agree not to use this confidential information. Boom, you're protected. Another option, but this is more complex, would be to register your intellectual property. So designs, patents, and trademarks. Trademarks are not really intellectual property, so they count as it, but is not applicable here. You can register designs and patents, but there are certain requirements that they must meet. Patents, for example, must be novel. So here it's best to see an IP attorney who can help you find the right fit for you. Be warned, however, it can be expensive and it is a very, very long process. I mean, at minimum a year, but possibly longer. Then copyright is actually much cooler than those two because it comes into existence automatically. The only requirements for copyright would be that it is an original work and that you've reduced it to writing. So if you were to go sit down this afternoon and write a short story, if it's your original idea, you've typed it out, you automatically have copyright over that. So those would be my two bonus tips for entrepreneurs. So contact us, please, if you want any further information. For me, if you have any further ideas of things that you would like to see covered in these webinars, I know, for example, there's much more that can be said about shares and funding, and labor is also something very important for companies to understand their relationship with employees and things like that. And then, of course, compliance with very relevant acts, such as the Consumer Protection Act, protection of personal information. But please pop it in the chat now or send me an email if you've got other things that you feel should be covered in sessions like these. And then Merlin, please contact him if you need actual legal work done. I want no part of that anymore, but he will happily help you. Thank you very much.
Awesome. Thanks, Leana. I've been scribbling a few questions here, and I see they're filling in the Q&A thing. I think people are just processing them before they put them in there. I'll try to more go chronologically, and Merlin, you're welcome to put your camera on and unmute yourself too whenever you're ready. I don't know if you're still doing your hair or changing out of pajamas or something. Maybe one getting earlier into your presentation, and there's some related questions to it there. So you mentioned liability and that, registering a company creates a juristic person, and then you've limited the liability of the shareholders. But then,
Can I go?
I'm sorry. But then, so in a PTY versus a listed company, there's different things. Can you just unpack? Most of us aren't going to list a company. Like, really, startups don't ever end up IPOing in South Africa, and that's just what it is. So what does that liability mean for us as directors and shareholders of a PTY versus that of a listed company? And those are two different roles, directors and shareholders. So how does it differ? Like, directors are a proxy for the shareholders, and then are they a proxy for liability? Like, how does that work? Just so that we know, we're a director of a company, we're a shareholder of a company, even though I'm the one director and shareholder, but I'm not completely limited.
So, Brandon, this is actually a very complex question that South African law itself has not fully answered yet. Merlin and I actually did a case about this a while ago. So shareholders are almost they are I can imagine really no circumstances under which a shareholder would be held liable. It's the directors really who come under fire. For example, if you do that reckless trading and so, as I said, you can be held criminally liable, and people can come after you yourself for that debt, but it is quite difficult to prove. And this is also something that you'll see with in public companies, exactly the same. If we think of Marcus Jooste of Steinhoff, I think they have either taken action already or are very seriously considering doing it. So it's the same in both of those, but either way, as a shareholder, you are really isolated. I mean, how can you hurt yourself is essentially the question here. If I decide to burn down my house, that's my business. But if the person who is my proxy, as you say, decides to burn down the house when I'm not okay with it, different story. I don't know if Merlin perhaps wants to supplement here.
Does that apply to a PTY also, the director
Yes.
and that liability? Okay, so not just listed companies.
No, but listed companies and private companies.
100%. Thanks, Leana, and thanks for having me. No, I wouldn't add anything further. I just think the one question that I would have wanted to clear up is that there's no distinction between your private company, which is your PTY Limited, and your limited company, which is your public company. The director's duties are the same in respect of the Companies Act, except that with your listed company, which is something you would register for, which is where you have listed shares on your local stock exchange, would add certain requirements on top, which is over and above your statutory requirement.
Excellent. That's very helpful clarification. So if you're a director and a shareholder, if you haven't given over control of your company to a proxy director as the shareholder, then limited liability is limited in its actual effect in the business, which is, I think, unique in South African law, that you can't just, steal money and run away and then it's limited liability. So we're quite progressively helpful in that. There's a question on everyone in startup world knows the Delaware C Corp, and what is that exactly? And why is that a thing? Why does everyone talk about that US based company? And then because that's a specific state and that state has specific laws that apply with tax and incentives and everything. Is there anything similar to that in South Africa now within the Companies Act?
No, I think perhaps you and Josh would be in a better position to explain C Corps, but my understanding is basically also that it is beneficial for US companies to register their company in the state of Delaware as opposed to others, because there are various advantages attached to it. In South Africa, of course, because we're not a federation, our provinces don't have different laws. Our company law applies nationally, so it doesn't matter where you register your company at all.
Maybe let me follow on to that, so then I'm actually a director of a company that's setting up a business in the Netherlands, and then they're going to have an operating company here, and the IP is going to be held offshore, just really for tax purposes. And I think that's really what the C Corp is about. Are there any nuggets or tips or anything as people are starting to think about how this happens? Because the impetus behind the Delaware C Corp question is tax incentive. What are some ways that you can do it 100% above board legally, but then also protect yourself, and not just protect yourself, but also incentivize the globalizing of your commercial entities so that you can move into other markets and attract foreign investment? Because it can be problematic when you're paying so much tax locally if you could pay less tax elsewhere and all of that. Any tips or things that you've seen to think about, maybe 3 to 5 things to think about if I'm a founder trying to navigate that space?
Merlin, do you happily want to take this incredibly complex question this man has asked about tax law?
Brandon, your question is not only based on tax law, but international tax law. And you delve into a very specialized field of law, and I wouldn't venture any guesses insofar as that's concerned. However, I do just want to reiterate what Leana said, that we have national statutory, the Companies Act applies nationally in South Africa. And what's really important is that our company's tax rate is a flat rate at 28%, which has just gone down from 29%. So, I mean, that's incentive in my opinion as well. And that rate, I think something else important as opposed to a sole proprietor is that it's on your profit. It's your income less your expenses, and then based on your profit. So little tips for companies is always, like you said, I think you mentioned that your Netherlands company is going to be the holding company for the IP. And naturally, it's going to be licensing it out to its South African subsidiary. And that already creates an expense on your South African subsidiary locally. So your expense column is already, for example, 10 Rand. And your income column is 0 because you haven't really started trading yet. So you're not making any profit and you're not being taxed on anything. So that's something really important to set up the structure and how your parent companies liaise with their subsidiaries. Those are really structures that can be done quite neatly for tax purposes. But other than that, I can't think of anything that I would venture into in this seminar, in this forum.
That's awesome. I think that's a very clear thing to make sure is noted. It's the flat tax rate is the thing here, which is actually helpful for budgeting. It doesn't go up and you don't have to keep it under a certain amount to make sure that you don't go from 25 to 35 or whatever those thresholds are. So very helpful. Thanks for navigating the complexity of that. So there's a couple questions here on, Leana, some of the diagram you took us through, 100,000 shares, and then there's 3 and they each get 10. And there's a question specifically on slicing the pie. I don't know if you guys have dealt with a specific case where the founders didn't register shares outright, or they agreed to something in their shareholders agreement where we'll work towards something and then slice the pie after some time. It's probably in the vesting thing. But then, yeah, I think you answered it quite well there, but have you seen the slicing the pie kind of thing? Have you seen anyone register the company and issue the shares after some time getting it up and running? Maybe there's investment that's come in a convertible note or a safe or something like that, where it's been, maybe if you have a good or bad case where that's happened, where you don't register everything and give the ownership of everything outright, but they kind of wait a while to see what value have we each put in? Or is there a different way to think about it?
Merlin can correct me here, but under South African law, as we now said, shareholders are the owners of the company. The company can't exist if it doesn't have owners, because certain decisions fall to shareholders. For example, the one that I used, you want to sell the majority of the assets of a company. So there has to be someone who makes that vote. So if you think back to those graphs I showed, you would start off by issuing a very small number of shares to each of your founders, and then build that up over time. And then, of course, so the authorized versus the issue shares. Authorized shares is how big is the pool of shares that you have to give away over time. At any given point, you can take a portion of that, let's say only 30,000 of the 100,000, and issue that. And over time, you can issue more and more and more and slice the pie further. So then, of course, there are things like safes, and so they come down to what we call an option. So that gives someone the option to, at the expiry of X period of time, or once a certain goal is reached, they have the option to buy X number of shares, which would then, of course, also dilute the rest of the shareholding. But I don't know if that answers your question, if Merlin perhaps wants to supplement.
No, I think that does sum it up, but I think it also just touches on what a Nathan Pillay has asked in the questions about whether you should leave aside shares for a later stage. And what's important is that you understand the distinction between authorized shares, which, for example, would be 1,000. You only have to issue out a small percentage of that, leaving the remaining shares to be authorized at a later stage. Those shares are not sort of legal property at that stage. They're only just a book entry. And they can, at some stage, once they are issued and shareholders have subscribed to them, they then become building blocks of the company and have voting rights, so to speak. And that's, I think, important, that you don't have to keep 10 shares aside in the bank, so to speak. You can always authorize them at a later stage when you intend to get on an investor, etc.
Awesome. Maybe one additional caveat to that is, if you do register the company, issue the shares, and there's that holding. I've seen some businesses where the founders, if their market rate because of their experience and qualification would be 100,000 Rand a month. But the startup can't afford that. So then instead of taking 100, they raise a little bit of money, they're paying themselves 25, then they create a loan account into the business at whatever their market rate is. And the other 2 or 3 founders do the same. And they have an agreement between themselves what that market rate is and what they're going to pay themselves. And that loan account builds. And then they've created an activation where at a point in time or some event in the future where they raise money or 24 months out, that loan account converts to equity, and then they start getting their normal salary. And I've seen that work quite well, especially when you don't want to take on additional funding sometimes, and it at least keeps the equity in the house as it is. So that's another, that's for free.
No, I mean, I must just say that pretty much everything that I've touched on here, really, we can do a 5-hour presentation about each, I mean, shares alone is madness, what you can do with it.
Yeah. A few more here. I'm glad we have so much time. We can get to a lot of questions. Does the incorporator have legal liabilities? So I guess incorporator, if you're listing a company, as well as if I pay you to register a company for me, do you have any liability?
So an incorporator does not have to be a director of a company at all. And the incorporator would, I cannot think of any circumstances under which an incorporator would carry legal liability. So just to clarify, the incorporator is literally the person who registers the company. That's all they do. But mostly, if you're registering your own company, you are an incorporator and a director. You'll just literally on SIPS's form, it's a box you tick to say that I am both. Simple as that. So the answer is no.
Yeah, so they're a service provider, as an accountant would be or something. Awesome. NDAs. So we, Launch Lab, obviously we get applications all the time and people want to come and tell us about their idea, and they usually lead with an NDA. So you walked us through why those are important and all of that. Have you ever seen one prosecuted? And practically, sometimes they are useful if you're going to an investor or you're going out to a market, your investor wants you to have an NDA just to protect themselves. When are they useful and when are they actually surplus?
Merlin, do you want to go first?
Yes. You know, it's very interesting about agreements. I would probably liken it to a grudge purchase, because people would very much, you wouldn't see the use until you actually need it when you get to a courtroom. And an NDA is exactly the same thing. I can tell you now that I am busy with a matter where we are enforcing an NDA. And the important thing there is that when you want interdictory relief or injunctive relief in American terms, so you want to stop someone from running with your well thought out idea, you need to be able to show the court that you have a right to that idea. And a non-disclosure agreement will invariably say that this information is confidential and you agree not to use it. So in other words, we create a contract between ourselves where you agree not to use it. And that's really important for you to, on an early and as an interim measure, to stop someone from running with your idea. Now, the reason why they do become superfluous is because we do sign them sort of willy-nilly, so to speak. And usually they are for, you know, ideas, really just ideas. And those ideas almost never get turned into something of value. But I can assure you that if your idea does get turned into something of value, you will have wished you signed an NDA with that party to stop them before you actually get to court 2 years later to prove that you are the owner. Because that is the problem with litigation, time. So you want to stop the person from actually using your IP and then prove ownership in a separate legal proceeding. So I would not be able to sum up the importance of it. It depends on the circumstances, but I can tell you now, when you look at someone using your idea, you would have wished you signed one.
Awesome. There's one here for foreigners registering a company. So do you need to have a visa or any kind of, what is the minimum immigration status that you can have to register a company? And then what limitations are there on shareholding, directorship, and all of that for foreign entities wanting to work in, direct, or own shares in a South African PTY?
So as far as I know, all you need is your passport number. There are no limitations on that. However, for foreign companies hoping to like open a branch in South Africa, that is a whole other process. But for you as a foreigner to start a company, you follow the exact same process as everyone else, except where I, as a citizen, would type in my ID number, you type in your passport number.
And just to dovetail on that, sorry, Brendan, you have no limitation on being a director as well as a shareholder.
And maybe a little nuance, non-executive director or executive director, because that does start to muddy. So if, you know, well, maybe I'm less helpful because my wife is South African, but for whatever it is, I could be a non-executive director on a business, but as a foreigner, what are the requirements for me to be an executive director that's working in the business day to day versus just giving advice through Zoom every now and then?
So the distinction between executive and non-executive directors only really becomes relevant with public companies. In a private company, it's just a name. I can call myself whatever I want, executive, non-executive director, it doesn't matter at all.
For practical purposes, I do agree with Leana, but for strictly speaking legal purposes, your executive director is essentially also an employee of the company. I think Leana mentioned 3 hats earlier. So when you are an executive director, you have all 3 hats and you've got to change them interchangeably when you are dealing with issues related to the company. When you are a non-executive director, you only have 2 hats because you're not an employee of that company. You're there purely on an advisory basis. And I think that's the one distinction that you could take away from that.
Okay. So if I register a company and there's a really brilliant Estonian that's relevant to my business, that's strategic in that market, I could bring them on just as a non-executive director, and I can work with them on paying them, I don't know, 20,000 Rand a year just as serving me for something, and there's no limitation there. But if I employ that Estonian person to run my biz dev in Europe, then that's where there's other things that come into play. But that's not Companies Act, that's immigration and employment.
That situation, though, as I mentioned, something that I believe is very useful for companies to learn about and explore, also labor law. Labor law in South Africa is quite tricky when it comes to when someone is an employee. So you can have a contract with your Estonian that says he is not your employee, he's a non-executive director. However, if he meets certain requirements set by our labor legislation, he will be deemed an employee, regardless of what the 2 of you agreed on.
I hear another webinar coming soon on labor and employment practices in startups. That might even be in the other question there, one of the most common mistakes. We'll save that one for more to the end. Let me look at a couple more of these. Partnerships. How do you approach that? If I'm sole proprietor, that's obviously, dangerous, but I can just go and sell cupcakes on the corner and I'm already a sole proprietor. So that's easy to do. But partnerships, do's and don'ts, and wisdom nuggets as we approach that, if that's something that one of us would want to do.
Go for it, Merlin.
Partnerships are an interesting sort of quasi-hybrid type of structure because the law regards them as separate, save for when they run out of assets. And then they come for the 2 members as sole proprietors. Let's assume there's 2 after the fact. So, from a advisory perspective, you would stay away from it, and you'd rather enter into some sort of joint venture agreement where you introduce a new company and you both are directors, and the company then does the business that the partnership envisioned. Partnerships used to also be an interesting thing for lawyers because they would, as a partnership, create a law firm. The problem with the partnership is that when you change the number of partners, you've actually got to go through a process of winding up that company, divvying up the proceeds to each of the partners, and then starting a new one with 1 less partner going forward. So it's a massive accounting and administrative burden And with companies with limited liability and sort of juristic personality, which is indefinite, it just makes for a much neater, easier structure to use.
So Merlin now actually brings up that is one of the distinguishing characteristics between, for example, a partnership and companies that are regulated by the Act. Those companies continue their existence regardless of the shareholders and the directors changing. The entity lives on because it's separate. But in the partnership case, it's a bit different. And as he said, stay away from it. I can say that during my years as an attorney, I had to liquidate a few partnerships. It is incredibly messy and far more complex than it is to wind up a company.
I'll put it this way, a marriage is a partnership. So think of it as a divorce.
Exactly.
Yeah, my cousin is a partner in a law firm in Joburg, and I think there's certain professions that they require to do that. We're talking about more tech startups than law practices and advisory things, but yeah, I'm sure if you could have a different structure for the way you're working your business, you would jump into a PTY tomorrow and not have a partnership
definitely.
in the legal firm. Getting into Section 21 and 18A, we haven't touched. You didn't explain much of that because we're talking. These are businesses. Sometimes it is helpful for a business to have that. There's a few cases around where we've worked with startups that had a trust that owned a portion. In Stellenbosch here, there's quite a prominent private equity firm here locally that has a foundation, a trust that owns 2/3 of the portfolio of several billions. And if it's that much, obviously it's not just a tax dodge, but some of them for certain purposes want to also have a public benefit that they've set up in the business where a community could own shares in something. Any useful ways or reasons or something that you've seen people set up NPCs and Section 18A or Section 21 where it's been useful to the business?
Well, and I think you've far more experience with I than that.
It really is a difficult question because once again, it delves into the tax arena, which is just a highly specialized area of law. And if that is the primary sort of reason you're looking at it, that would be one thing. And I would urge everyone to get independent tax advice because we are dealing with lots of internationals and there may be double taxation agreements between the parties with bilateral agreements. It's just all very complex and would be impossible to really delve into it with any detail in this forum. But yes, you are right. There are trusts, in my experience, which have public benefit legs to them. These normally become shareholders when you are dealing with your Black economic empowerment requirements. And if you do have some sort of structure like that within your trust, and that trust then becomes an owner, it contributes greatly to your BEE scorecard. But once again, that is also probably a seminar for another day because there are different levels and different requirements for dependent on your turnover as a company. So they really they range from very simple to intensely complex.
I feel like I just quickly want to throw in the disclaimer here for attorneys everywhere. You know, when you're at a bar and you're standing around and you ask your friend who's an attorney, hey, I just have a quick question for you. In law, few questions can be answered quickly because few things are as simple as black and white. There are some things, but generally you can't discuss it in the abstract. You need what are the facts so that we can see how the law will play out around them.
Awesome. Here's another complex one. If you want to sell a product you created to an existing company, is copyright good enough for protecting it as your IP? Or should you form a separate company just for selling that product? Is that also mostly a tax structuring thing? Or when is it with IP and company and ownership of that specific thing, when is it needed and good to set up a whole company just for that? Or when can your, I guess, I don't know if the right legal word is de facto IP ownership or copyright, is that enough?
So I think probably this will largely come down to tax as well. I do know from what I've experienced that often people prefer to hold IP in their personal capacity. So they don't put it in the company, because then if something goes wrong with the company, that can be sold off and then you lose your IP. But for me, I think it would come down to a tax consideration. If you know you're going to make a lot of money out of licensing this, so let's say at least $500,000 a year, then I think it would be better to have that in a company where your tax would be much lower than as to you as an individual.
Yes, I concur with that. The highest tax rate in South Africa for an individual is 45%. And that would be around about 1.2 million rand, which I suppose would be a small company. So if you were looking to earn more than that in turnover, that would come into your personal estate and you'd be taxed at 45%. So I would say, yes, register a company and make sure that the company is called ABC Pty Limited Intellectual Property. You know, it's your property holding company. It is just the best way to always protect your intellectual property from the trading company as well, and creditors looking to attach assets should problems arise.
I can add to this. I answered someone in writing earlier, pretty much when you want to start looking at tax as a factor in your decision making, you're looking at about 200 to 300,000 Rand a year. Once your company starts generating that much income, that's when you should start speaking to a tax specialist, and so, because that's when you go over that 28% ledge.
Awesome. We just have a few minutes left. Maybe I'll throw this out to both of you guys. And sadly, you probably see more bad situations and mistakes than, wow, this company comes to you and they've done so well, having their MOI and their shareholders agreement and everything just sorted, and it's crisp and clear. Maybe each of you, one common mistake that you see that founders make, that if you can just do this right, it will make our jobs easier and your life so much less stressful if you aren't naive early on and don't make this mistake. What is maybe one or two things each of you?
Well, I'm going to steal the easy ones. You're more experienced than I. You can think of more interesting things to say. So the first one is, don't just sign contracts. Speak to someone. I'm very hesitant to say that even if it's a simple contract, you might be able to understand it. That is the truth. But in reality, have someone look at it. Yes, it is going to cost you money, but would you rather spend, let's say, 3,000 Rand now, or have everything you've worked so hard for taken away from you a few years from now? I think the answer to that is quite plain. And then another one, and this is very good attorney advice, get it in writing. You can record voice notes and things like that, but get it in writing. If you have it in writing, it's very, very hard to dispute something. That doesn't mean necessarily a contract. It can be emails, what the hell ever. Just put things in writing.
Okay, thanks. You took none of my easy ones, so that's great. Thanks, Leana. I really have seen problems arise with shareholder agreements. This is not something dictated by statute. You don't get a shareholders agreement when you register your company. You've actually got to decide what it is with your partners. And it's a massively important document. It can't obviously obviate the statutory position, but it does govern the relationship between you and your shareholders. An important thing, when your shareholder decides to sell his shares, that he needs to sell it to you first. If your partner should become deceased, unfortunately, should that fall into his estate, or should it be transferred to you? Do you want third-party partners coming into your business at a later stage? These are things that are not obviously set out in the Companies Act, which need to be regulated in a shareholder agreement. And come tomorrow, when circumstances change, you really would have wanted a shareholders agreement which is tight and tells you what it doesn't need to be the 21 pages that you'll get from your lawyer. It really needs to set out whose responsibilities are what, how we deal with shareholder loan accounts, and what happens to my shares if something happens to me. That's really important. Leana spoke about the hats, and I've touched on about the hats. You might be sick and tired of the hats, but the biggest problems I see is when directors forget which hat they are wearing. As a director, your responsibility is to the company. As a shareholder, your responsibility is to profits. As an employee, your responsibility is towards that director. So you need to understand which job you're doing and what the purpose is so that you can really do that job to the best of your ability. Brandon, you mentioned something about executive, non-executive directors earlier. It's just dawned on me that we haven't mentioned, it would be really hard pressed on someone to be an executive director of two companies who are at odds with each other, who are in for-profit companies in the same industry. Because what I say to you is that your responsibility is to the company. How could you, in good faith, make a decision for company X when you are also sitting on company Y's board and they are both in competition? Because either decision is going to prejudice the other company. That's where non-executive directorship really becomes important, because there you sit as an advisory role and you'll find non-executive directors sitting with 10 positions as non-executive director, because they aren't executive directors of that company in the day-to-day running of it. So there's an advisory capacity. Sureties. It's what makes or breaks directors at some stage. You'll sign a surety with the bank, and that's probably it. Try and stay away from sureties as far as possible and limit them. A surety should never be unlimited. It should be limited to the amount. If you take an overdraft facility for 10 million Rand, try and limit that surety to R1 million, so that you aren't exposed for the company's full debt towards whatever creditor it is. These are the things that end careers very early on. If the company falls, it's a separate juristic personality. You don't want that debt to be imparted on you. And I think those are the things that I think are really important. And that's understanding the hats, shareholders agreements, and sureties.
Just perhaps to clarify quickly, so a surety is if you agree to be liable for someone else's debt, if they can't pay it, then the creditor can come knock on your door and say, hey, come pay. So that's what Merlin was talking about now. And then perhaps just to end us off on the hats, really so important, as Merlin says. He and I once had a client, my absolute favorite client. We explained to him the hats, and so to him and his business partners. He was perhaps not the sharpest pencil in the box. And when he one day pitched up at our offices after we discussed these hats, he was kind of like, where are the hats? He thought that actual hats would be doled out to him and his business partners to wear.
It would help for clarity to know what hat I'm wearing on any given time. Then you have a physical representation of how that works. Because it is important to make sure you have to pause and, okay, right now I'm this role. And then in the same conversation, okay, now I need to think about it as this role. Yeah, awesome. Leana, Merlin, thanks so much for your time. It's been very valuable insights given, and especially what's always interesting is those stories, like the nuances of how it works in the real world, and we can get into those. So it's great having your experience come to play and yeah, contribute to what we're building here, turning seemingly impossible into world shaping. So thank you too for giving your time, and everyone else that's been in the session. We hope it's been valuable to you. And I think there do need to be a couple webinars on tax as well as employment law. So watch this space. We'll be coming back to you guys and chatting. Thanks, everyone.